Democracy is all about the balancing of interest. Various checks and balances of the systems ensure that the mob does not rule the rooster, and at the same time, too much power is not accorded to a particular organ of democracy. In most countries, the art of monkey balancing has been handed over to the judiciary. It interprets the respective constitutions to ensure that the original intent of the constitution makers is reflected in every part of the polity. Hi and welcome to TFI English, the national socio-political analysis arm of the TFI Media Group. Coming back to the story, in this video, let's talk about India's judicial system being at interesting crossroads. So let's begin. The internet has done wonders for the world, but its biggest contribution is that it has given belief to the common individuals that intellectuals differ from them only in using sophisticated words of particular lexicon. This is possibly the reason why judiciary, considered a sacrosanct and sometimes beyond questioning institution, is now under intense scrutiny. Media and social media trials have become common, and at the same time, the institution itself has been, by and large, reluctant to speak against it. Now, CJI Ramana has taken the onus upon himself. Recently, CJI put forward his opinion on the tussle between media and judiciary. He accused the media of running ill-informed and agenda-driven debates on judicial cases. He termed these showdowns as running a kangaroo court. A kangaroo court is a court in which the evidence, most important feature of law, is not much relevant. According to the numero uno judge of the apex court, this phenomenon is detrimental to the health of democracy. CJI was particularly critical of electronic media. He explicitly stated that stakeholders are overstepping and are breaching their responsibilities at the same time. Stating that electronic media has zero accountability, CJI said, by overstepping and breaching your responsibility, you are taking our democracy 2 steps backward. Print media still has a certain degree of accountability, whereas electronic media has zero accountability. CJI's comments can be seen as a pushback against the Supreme Court judges being under intense scrutiny for their comments. People and even media personalities have been finding out irregularities in opinions of the Supreme Court on cases involving similar facts and issues. Surely the apex court must not and should not have any problem with the logical analysis of judgments. However, often public opinions are driven by emotions rather than logic. That is why during recent controversy involving judges' comment on Nupur Sharma, people started to take personal dig at the judges. This is highly commendable on people's part. No matter how much you disagree with particular judge, unraveling family history will not solve the problem. Even Justice Pardiwala too criticized the phenomenon. On the flip side, the most important facet of judicial accountability is providing reasoning for whatever conclusion they draw from the particular fact. It was not adhered to in the case of holding Nupur Sharma's loose tongue responsible for country being on fire. Additionally, the observation was also oral, which is not the part of records. This is what logical individuals in both electronic as well as the print media are demanding. They are constantly asking questions about the application of logic in different aspects. Skirting these questions off by terming them as kangaroo court proceedings is unadvisable. A judicial mind should be wise enough to separate the noise from the news. If they are not able to do this, then certainly there is a need for tinkering with the training manual of judicial academies all over the country. Another problem hurting the perceived credibility of Indian judiciary is its relative opaqueness as compared to all other organs of the democracy. While politicians and even bureaucrats are compulsorily required to furnish their assets and obligations in public, there is no such requirement on judges. Recently, Bibek Debroy, the chairman of Economic Advisory Council, pointed out this problem in his column co-authored by Aditya Sinha. In fact, the apex court has squashed any such attempt. Though in 1997 the Supreme Court had adopted a resolution regarding mandatory disclosure of assets by Supreme Court judges. On its website, assets of only 55 judges are present for everyone to see. 2 of them are in fact serving judges, one being the Honorable Chief Justice himself. It should not be a matter of speculation that this is not a good example for the High Court and lower court judges to follow. This is in stark contrast to the practice adopted by most countries. As Bibek Debroy pointed out, in nearly 100 countries, Supreme Court judges are mandatorily required to disclose their assets. It is not a sign of mature democracy that judges are living in separate regulatory silos. Judiciary is one of the four pillars of democracy. Judges have been provided some independence because often public sentiments go haywire and populist leaders use it to peddle their ideological agendas. But it does not mean that they are totally independent from common public. Judiciary is independent from executive and legislative, but not from public opinion and scrutiny. Taxpayers spend 5 crores rupees per year on every judge. Not only that, an initial capital expenditure of 10 crores is also borne by the public. And to that, their personal independent opinions. The public sees the judges being treated well above others and being provided with special privileges. But any privilege which does not serve public interest is not acceptable to the public. People want to know whether the judges are taking advantage of their prestige in society or not. In modern times, these advantages come mainly in the form of monetary benefits. This is why there is insistence on disclosure of assets by public servants, judges being one of them. Ironically, judiciary will be the last one to join the transparency bandwagon if and when it decides to do. Earlier, the public perceived delayed judgment was the only major big problem with the judiciary. But the free availability of judgments and court clips has brought out more negative facets of the institution. People are now demanding universal applicability of logic, and their level of toleration is diminishing day by day. At the same time, postmodernists whose documented principle is that they do not believe in logic and objective reality are constantly dominating the field. Tough job for judiciary to follow.